The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. We are, of course, holding this session remotely due to the ongoing pandemic. I am Justice Rubin. I'm lucky to be joined, and you are lucky I am joined today by Justice Blake and Justice Lemire. The rules of argument are the same as they are in our courtroom, which is to say it's 15 minutes per side with no rebuttal. We have read your briefs with some care, so you may want to get right into your arguments, but you are free to use your time as you will. You need not use all of it if you finish your argument. As I say, we have your briefs. The first case we are hearing this morning is number 20-101, Commonwealth versus LEBRETON. And we will hear first, I believe, from Attorney Piacentini.
Thank you. Good morning. May it please the court. The Commonwealth is appealing from the motion judge's decision to allow the motion to suppress without a hearing based on the Commonwealth being unable to proceed forward without an indispensable police witness. The Commonwealth is arguing that the motion judge did abuse his discretion when allowing the motion to suppress and denying the Commonwealth's continuance. Your Honor,
can I ask you, as I understand it, there were 5 continuances. I think at least 1, maybe 2 times it was marked no further. And I know that that sometimes happens and the case gets continued notwithstanding, but the record is a little thin on this. It seems as though the trooper may have been out on a medical leave. I don't think the judge was ever presented with any information in terms of documentation about his status and why they needed these extensions. And then the concern that he was coming to court that day for another case. So with all of that, how do we get to he didn't abuse his discretion by allowing the motion? He meaning the judge, I'm sorry.
thank you. The Commonwealth would argue that he abused his discretion to deny the Commonwealth's continuance and allow the motion to suppress because it was tantamount to a dismissal with prejudice. As the court held in Clegg, to dismiss where a dismissal with prejudice, such sanctions should be reserved for egregious misconduct.
In Clegg, how many occasions had the case been continued?
It was only, from my understanding, it was only 1 or 2, Justice.
Well, let me ask you this.
Yes.
Let me ask you this. So you're not suggesting that if the judge had dismissed it instead of allowing the motion to suppress, would you have said he is abusing his discretion then?
At that point, I do know the record reflects that we did ask for a dismissal without prejudice. At that time, the Commonwealth would argue that there was not an abuse of discretion, where that.
So it's the allowance of the motion without a hearing. It's the allowance of the motion where no evidence was before the court whatsoever.
That is correct. With the allowance of the motion to suppress, therefore the Commonwealth could not proceed forward at all with the prosecution of the case. And the Commonwealth would argue that the public has a strong interest in prosecuting criminal behavior and this case. So with the suppression of that evidence, the Commonwealth could not go forward.
Where if the judge had dismissed it, it would have been without prejudice and the Commonwealth could choose or not to bring the case back. Is that correct?
Exactly. That is correct, Your Honor, which the Commonwealth would argue, which would be a better or a more sufficient avenue to go down rather than to dismiss or strike that, allow the motion to suppress, which would be tantamount.
Is there any case that stands for the proposition the judge can either allow or hear a motion when evidence is not presented?
I do not know of that. I apologize. I do not know of any of that case which would have that information.
You were suggesting that Clegg was controlling here, but aren't the facts here more aligned with Burston, which is what the district court judge relied on?
The Commonwealth would argue that Burston is not the case more like this one at hand. In Burston, the Commonwealth in that case cited reasons for discovery issues as their reason for their request of a continuance. The prosecutor in that case came out on the record and stated that we did not summons any witnesses in that case. And therefore they were asking for a continuance because of discovery reasons. The court in that case held that there was no good cause that necessitated the continuance because the defense was ready to proceed forward even without that information or that discovery. Here in this case, the record is scarce as to whether or not the trooper was summoned personally. However, the record does reflect that there were 2 other troopers who were present. The Commonwealth will concede, though, that the record does not reflect that the trooper specifically needed for this case was summoned. However, the Commonwealth would argue that it did act in good faith and due diligence in order to secure the trooper for this case, unlike in Burston.
What evidence of due diligence is there? I don't see that.
The Commonwealth would argue that the due diligence of summoning other witnesses, Justice, would be evidence of that due diligence. However, we do agree that the record is scarce as to whether or not the trooper was summoned.
Didn't the court in Burston allow a motion to suppress as well?
In Burston, yes, they did allow the motion to suppress in that case. And they did state that it was not an abuse of discretion, again, because the Commonwealth did not use due diligence. In such cases as held in Burston, Clegg, as well as others, the court has a wide discretion in allowing or denying a motion to continue.
Are you suggesting, though, that it's procedurally incorrect to allow the motion, or that the judge abuses discretion in not giving a continuance? Procedurally, I'm not sure whether the judge was allowed to rule on the motion instead of just dismiss the case. But you seem to be developing an argument that because the Commonwealth had used due diligence, the judge should have granted the continuance and was therefore wrong in granting the motion.
Yes, you're right. I guess it's twofold. So the Commonwealth would argue that the Commonwealth did use due diligence in trying to secure the trooper, and that allowing the motion to suppress was in error because there was an abuse in discretion, because that allowance of the motion ultimately was tantamount to a dismissal with prejudice.
I understand, but you're not suggesting procedurally he could not have done that.
That is correct. That is correct. Where he does have wide discretion, the Commonwealth
procedurally, was his option to only dismiss, or did he also have the option to rule on the motion?
I think he had option to do both. Justice. I think he had option to do to allow.
On what basis could he dismiss? I don't see that.
Where the Commonwealth was answering not ready for the motion to suppress because their unavailable witness was.
I'm sorry, we have a technical glitch. Why don't we pause the clock and see if we can get Judge Blake back? I apologize for that. I hope you will bear with us. These things seem to happen.
I think we're around 7:19 or something.
Yeah, it was around 7 minutes. I've recorded I paused the recording.
I'm sorry about that, counsel. I'm sure it's
Do not worry.
difficult enough to argue orally and to do it on Zoom. So
Thank you.
I do apologize, but we'll get Judge
Please.
Blake back.
Possibly. We're not in the middle of that windstorm anyway, so.
Although who knows where she is and what's going on.
She just texted me that she just got kicked off for internet and is trying to get back on.
Seems reasonable, I guess. Non-payment, did she mention non-payment of?
Here she is. I'll admit Judge Blake now. So,
Let's
Justice
keep that
Rubin, was
between
it, should we give 7.5 minutes to restart?
That's fine. And you can have a couple more seconds, Attorney Matos, if you need it. We can't hear you right then, but okay.
One moment, please.
It's okay.
I don't know what happened.
This is what
Okay.
happens when you don't pay your internet bill.
Well, I did pay the internet bill and I just texted you to say, I don't know what happened. I'm back.
I got
I'm
the, we got
sorry.
the,
We got the text. Whenever we're back up and recording and
I apologize, counsel. I don't know what happened.
Okay, I'm gonna click resume recording, then I'll start the timer again.
thank you.
okay, counsel.
So I was asking you how the judge was in a position to dismiss the case. The judge wouldn't know whether you had other evidence aside from what was suppressed that might be adequate. That seems like that's a decision for the prosecutor. What to do if the evidence is suppressed, that a judge would be, I mean, maybe as a punishment or something. I just don't understand how a judge can dismiss that. That isn't that a judgment for the Commonwealth to make once they know what evidence they will and won't have?
The record does indicate during that hearing itself, the motion judge asked if there was any other evidence to proceed forward from the Commonwealth, where
On the motion to suppress, not on the trial.
on the motion to suppress, that is correct. Where the Commonwealth would argue that it could be in the discretion of the judge to dismiss without prejudice based on the Commonwealth not being able to proceed forward with that. This was the only charge that the defendant was charged with, which was distribution of Class B substance. With a dismissal or with the allowance of the motion to suppress, the Commonwealth would not be able to proceed forward with the case.
If the defendant had had a witness they wanted to have testify at the hearing, who didn't show up 6 times in a row, and it was marked no further continuances, and the judge ruled against the defendant because their witness wasn't there, went ahead with the hearing, would that be an abuse of discretion?
It could be, Your Honor, the Justice. The Commonwealth could argue that it could be an abuse of power or abuse of discretion, rather.
6 times they don't bring their witness and they're told no further continuances and they have no explanation. And you think that's an abuse of discretion?
It could be. I can't speak as to that specifically, where the case at hand is the trooper or the indispensable witness in the case. The Commonwealth may argue whether or not the defense could proceed forward with the motion without that witness.
Well, but the same could be said here. You could have given it a go.
That is correct, Justice. However, based on the facts of the case as well as the situation, the trooper was indispensable in this case. Although we did have 2 other witnesses, this trooper was the one who initiated the stop. The other troopers did not appear on the scene until later during the stop and the exit order of Mr. LeBreton. The Commonwealth would argue that there were other avenues that the court could take in this case rather than allowing the motion to suppress. One avenue would be to issue a bench warrant. The record is scarce as to whether or not the trooper had notice. The Commonwealth would argue that there were 2 other troopers who were present for this motion. In Clegg, the court did outline a number of other avenues the court could take in this situation, which was a bench warrant. Again, Clegg references that the public has a strong interest in prosecuting criminal behavior, and that a bench warrant, even though there might be some
Of course they do, but you're putting it on the judge. The Commonwealth is the one that didn't prosecute. I mean, to say the judge has to take account of it. The Commonwealth was told, I mean, the judge did take other avenues. At least once, the Commonwealth was told no further continuances. How is the system supposed to work if the Commonwealth doesn't take that seriously?
I understand. Justice, the Commonwealth would argue that although, again, the record is scarce, the unavailability of this witness lay beyond their control. The record does not reflect that there was medical issues. That seems to be in the background, that there was a serious accident. However, the record does not reflect that. Based on that,
but you didn't develop a record below by putting forward anything in the way of affidavits, and certainly or not even representations of counsel, and everyone seemed to at least acquiesce in the statement that he was coming in later in the day. And so that doesn't sound like someone who really can't make it in. That sounds like someone who you make them come in sometimes and you don't sometimes. And it seems like, I'm not saying this is what's true, all we have is the record. The record makes it seem as though the Commonwealth decided this wasn't important enough. And the judge called it yet again, and you had been told no further continuances. I mean, I don't know, that seems ill-advised to me. But you know what I mean? Obviously, no one wants to see a criminal, alleged criminal not prosecuted, so we find out what happened and punish the criminal if they violated the law.
Yes, the record is unclear as to whether or not that trooper did actually come in for the proceeding on that same day. I do know that defense counsel did reference that on the date of the hearing that they had chosen this date because there may have been another motion or hearing that the trooper was going to be present for. However, the record does not reflect whether or not that was true. Another avenue in which the court could take was once the trooper was present, the court could probe into his unavailability, and at that time take the proper measures as the court seemed fit, whether that was an allowance of the motion to suppress or other avenues. The Commonwealth would, in conclusion, state that such a sanction, it appears as though the court was frustrated with the Commonwealth's ability to secure that witness, which is understandable. However, the court in Clegg did state that such an allowance of a motion to suppress was tantamount to a dismissal with prejudice.
Can I ask, you describe it as a sanction. Why isn't it just denial of a continuance and we go forward? Sorry, you're not ready. You were told many times. Why is this a sanction rather than just a denial of a motion?
I apologize if I misspoke. The sanction in my argument would be to the allowance of the motion to suppress. Without that evidence, the Commonwealth cannot proceed forward the prosecution.
Okay, your time has expired. We understand your argument.
Thank you.
Thank you very much. We will hear now from Attorney Matos.
May it please the court, Attorney Rachel Matos for the appellee.
You need to move whatever microphone you're using closer to you. I don't know if that's possible.
Okay, is that better?
Much. Thank you.
May it please the court, Attorney Rachel Matos for the appellee, Mr. Mark LeBreton. Your Honors, I would argue that the judge did not abuse his discretion allowing the defendant's motion to suppress after the Commonwealth's fifth request for a continuance. Here, the Commonwealth had requested 5 times for the matter to be continued. This was at the Commonwealth's request. On 2 occasions, the case was marked no further continuance. So the Commonwealth was well aware that they needed to either summons in their indispensable witness to have them available for the next date. There were 2 prior occasions where this case was marked no further continuances. So the Commonwealth was on notice of that. At the 5th date, the judge was well within his discretion to allow the motion to suppress.
The defendant did not ask for the allowance of the motion to suppress, correct?
That's correct, Judge. That is correct.
The defendant asked that the case be dismissed as the Commonwealth wasn't ready to proceed.
That is correct. But the motion judge was well within his discretion under Burston to allow the motion to suppress at this juncture. This was the 5th continuance. So he was uniquely positioned to assess the credibility and the motives of counsel appearing in his session. As in Burston here, the judge's disposition may have been severe, but it was not an abuse of discretion. It came after a series of
Well,
postponements.
how do you compare this, counsel, to Commonwealth versus Borders, where we did say it was an abuse of discretion to allow the motion to suppress, and there had only been one request for a continuance?
Correct. So in that case, the case was dismissed when the witness failed to appear on the very first date. And the defense was made aware of the fact that the witness could not appear the day before. So that's quite different than the case here. Here, there were 5 requests. Numerous.
Right, but in Borders, there was only one, and we said it was an abuse of discretion. So you
Correct.
think this case is more like Burston than Clegg or Borders?
Correct.
Why?
With regard to Clegg, the burden was on the Commonwealth. There were numerous continuances due to the failure of the defendant to appear. That's not the case here either. Here it was the Commonwealth who reported not ready for each individual hearing, and at the 5th request, they still reported not ready, asking the court for additional time. They provided no evidence whatsoever that their indispensable witness had been summoned to court on that day, nor had they provided any evidence of it's not part of the record, any evidence of why he failed to appear. And with that, the judge was uniquely positioned to assess the credibility of counsel at that juncture, and he found that the Commonwealth was unable or unwilling to present evidence to support the warrantless search and seizure, and the burden was on them, whereas in Clegg, it was different because the defendant did not provide an affidavit in support of the motion. Here, the defendant did do that. So the burden was on the Commonwealth to provide evidence in support of their request for the continuance, which they did not do. And they did not have their indispensable witness ready at the 5th continuance when they were already on notice on two prior dates that they weren't going to get another continuance. So the defendant appellee's position is that the motion judge was correct and did not abuse his discretion in allowing the motion to suppress. With regard to, as in Burston, motion judge disposition, like I said, the motion judge was uniquely positioned to assess the credibility and manage the cases that were coming before the court. So he did not abuse his discretion. He was well within his discretion at the 5th continuance to deny the Commonwealth's request. So I would just, in summation, liken this case to Commonwealth versus Paula as well, where the same witness failed to appear not just once, but for 2 scheduled hearing dates. And the second time, although he had previously agreed to be present, he did not contact the prosecutor or offer any reason for his absence. In that case, where the burden was on the Commonwealth as well as it is here, because that motion was supported with an affidavit as it was here, it was held that the judge could reasonably conclude that the Commonwealth had failed to exercise due diligence in obtaining the available witnesses. And that's the same as the case is here. So I would just state that the motion judge was correct and did not abuse his discretion in this case by allowing the motion to suppress.
Okay, I see no other questions. Very good argument. Thank you very much to both of you. Arguments are always helpful to us, and the case is submitted.
Thank you.
Thank you.
Sorry about that, guys. I don't know what happened.
It happens.
It's all right.
Was I just gone?
Yeah, your screen just disappeared.
Just went away.
No frozen, nothing, just gone.
Just gone.
Oh, hold on a second, please.
But it's no big deal. I mean,
I think we're still being live.
Yeah, I'm trying to stop the recording.
that's okay. Only Jim said anything offensive. Oh, wait, it's still recording. Now I have.
All right. The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and I am joined today by Justices Blake and Lemire. The rules for argument are the same as they are in the courtroom, although we are hearing this argument remotely due to the ongoing pandemic. 15 minutes per side and no rebuttal. The next case that we will hear is number 20-740, Commonwealth versus Bonilla, and we will hear first from Attorney Fox.
Good morning, James Fox, on behalf of Alexander Bonilla. Mr. Bonilla advances a single issue appeal this morning. He challenges the evidentiary ruling by Judge Lang in the Essex Superior Court. In essence, Mr. Bonilla sought to admit text messages that occurred post-reporting to the Lawrence Police Department between his now wife and the mother of his children. The court precluded the admission of the text messages, seeing them as merely for impeachment of the mother's views of the complaint's allegation. On appeal, essentially, Mr. Bonilla argues that the text will be probative of bias, that Judge Lang impermissibly restricted the use of the text messages, that in this case, which was a closed case, that the restriction of those text messages unfairly limited his defense.
Do I understand your argument to be that it doesn't matter what the contents of these messages are, that it is the fact that the text messages occurred that you say would have been of value to the defendant?
Yes, and the text messages were included by the Commonwealth in her appendix at page 4.
I
But in
understand,
essence,
but you don't care what they say. It's the fact of the texting. Is that right?
yes, although
I'm
since
sorry.
they are in
No, go ahead. I didn't mean to.
there's a bit of an overlap here. I apologize. In essence, what they do reflect is that the mother of the complainant texting with Alex about whether he used to pick up the other son. So in my brief, I argue that the substance does not matter, but what it does show is there's an ongoing relationship post-reporting to the Lawrence Police Department.
What does that have to do with bias? I don't get that at all. I understand. I mean, repeatedly in your brief, you talk about an ongoing familial relationship, and that's fine and good. I don't have any idea how that helps the defendant. Can you explain that to me?
Well, I think Judge Lang acknowledged there was use of evidence like this commonly in these type of cases. In essence, that it is puzzling that after the birth mother became aware of these allegations, that she would permit an ongoing relationship with the other sibling. So there is a question about
whether she believed the daughter who made the allegations. That's about impeaching her for her credibility, right? Or about getting into the record whether the complaint seemed believable or not. Maybe that is your argument. That does depend on the contents of the text messages, I would think, because a text message that said, "Come pick up your stuff, you jerk," might not have that same significance. So I don't understand this familial relationship. I feel as if you've just moved on to whether she believed the daughter or not. So is that your argument?
Well, I have to unpack that a little bit, Your Honor. Yes, you could offer a scenario where that the text messages do not reflect a relationship. In essence, the text messages can be used for impeachment. They can also be used to show bias. That what the argument is, I apologize. There's a bit of an overlap.
No,
with
I know,
judgment
but I'm
between
having a hard time understanding. Please spell out the bias.
The bias would be that if the allegation, the Commonwealth's case depicts a family relationship that was breaking down, that Mr. Bonilla was, for lack of a better term, transitioning from relationship with Alicia to his now wife, Melissa. And there are allegations later made that he assaulted her daughter, Alicia's daughter. What the text messages would show is whether there's a bias against Mr. Bonilla, meaning that.
How does a text message show bias? Doesn't it show friendship toward him rather than bias against him? I don't understand.
Well, it factors into understanding the family relationship, meaning that why is he visiting with the other son if he committed these allegations, if he committed these assaults with the daughter?
Okay, I don't understand. I understand why that might mean that the mother didn't believe the daughter. It could mean a lot of other things. We have the daughter testifying, I think it was allowed in, that she thinks she was molested because she was not his biological child. And the mother might have said that. We don't know what the mother would have said if this cross-examination had gone forward. But I understand how someone who believed someone was a sexual abuser of children wouldn't let their child, even their child with that person, go visit them. I get that. And so if the contents of these texts were something about that, then maybe it suggests the mother didn't believe the daughter. I take it you're not quarreling with the judge's ruling that can't come in. So I'm trying to figure out what kind of bias we're talking about other than that, and whether there's anything based just on the texts, not on the contents.
Well, in essence, Your Honor, Judge Lang limited the use of the text to Alicia first having an opinion about the complaint's credibility. The paradox here is that the defense cannot ask the mother about whether she believes the complainant. That's clearly the jury's province. So the way Judge Lang set this up is that unless Alicia opined about the complainant's credibility sua sponte, the text would never come in. And what the defendant's argument essentially is today is that there is a utility for the text. It is beyond just strict impeachment, that the court may not agree that it helps, that this is probative of bias, but a jury may find it probative of bias.
If it's probative of bias, it's relevant. If it's not probative of bias and it can't come in for the mother's belief in the credibility of the daughter, then it's irrelevant evidence and there's no error in excluding it. And all I'm asking you is please explain how it shows bias rather than how it might show that the mother didn't believe the daughter.
Well, there is a fair amount of overlap there, admittedly, Your Honor, between whether she believed the daughter and whether there was bias. She took the daughter from Vermont down to Lawrence Police Department. I'm not sure the exact location of Vermont, but it's fair to assume it was a significant ride in to go to Lawrence. And the bias essentially is there's a tension here in the evidence, meaning that he's allowed to see the other son following the allegation of these assaults. So there's a question here about there's rather a value here that this may be probative of whether or not there was some reason behind bringing the complainant into the Lawrence Police Department that may show bias. I think it would help to unpack, look at the further evidence. It was a very difficult direct exam of the complainant as far as the bringing in the essential elements of the crime. The closing argument of the Commonwealth was pushing at some of the limits. I don't think either of those areas arose to an appellate argument, but what it does show is that it was a closed case. There was no identification issue here. There was no physical evidence. So basically the jury had their exclusive case, their entire case was an assessment of the credibility of the motives of whether the mother played a role in advancing this or not. it's at least, it's an,
Counsel, I don't mean to go over what Justice Rubin has asked you, but maybe if I could try and come at it at a different way. On page 17 of your brief, you say the substance of text messages is irrelevant. And to me, that's the whole issue in your argument. If it doesn't matter what the messages said, because you say it's irrelevant, then whether they show bias, attack her credibility, explain the interfamiliar relationship, help me get to that, because let's make it even more mundane. How do we know she didn't text her? I mean, we know because we have the record, but it could have been a grocery list for all we know. I think I'm confused by the issue of the substance versus the fact that a text message was sent. Do you have any case that can help me with that?
well, why don't we take it a step further from there? You have the text messages now. You have the proffered text messages, they demonstrate a relationship. So I can answer that question further, but
in your opening brief, with knowledge of what the text messages said, you affirmatively state the substance is irrelevant. So that you're telling us it doesn't matter what they say.
mine, I did not have knowledge of what they said. My understanding was that they indicated something to the effect that it was about picking up the kid.
Wait a minute, when you submitted your brief, you didn't know what the messages said?
No, they were not in the record.
But you determined that they were, the substance of them was irrelevant, although you hadn't seen them.
They were not in the record, Your Honor. I guess potentially
Did you file a reply brief once you got the Commonwealth's brief and their supplemental appendix?
There's no reply brief, Your Honor. I think the argument is fair that my understanding, if I could just address that from Attorney Seddon's argument, that my understanding was the text messages reflected some type of ongoing relationship about picking up the other son, or picking up the son.
Were they shown to the judge? Did the judge rule on the ability to cross-examine about them without seeing them?
I don't think they're offered to the court. I think that Attorney Seddon described them.
But why isn't that the end of the matter? How can you win on appeal if you didn't give them to the court to look at and make a decision? I mean, I understand if the mere existence, maybe that's why you say the mere existence. But I
don't know if I'm working with the record I have. From Attorney Seddon's argument, they depicted an ongoing relationship. And now maybe this is more into Rule 30 territory, although in fairness, they are in the supplemental appendix now. They probably shouldn't be in the supplemental appendix, given the way that things played out down below, but they're there. They're available for the court to use. And my understanding was that as they came into the supplemental appendix is consistent with Attorney Seddon's argument.
Well, if they're not in the record, and especially if they weren't shown to the judge, I don't see how we can use them because they're in the supplemental record appendix.
That's a broader question about how these appendixes are put together. I agree with you on that. I think that I've often seen these appendices where things get thrown in, whether or not they're introduced down below. So my argument essentially is the way it's structured in the brief, that it depicts an ongoing relationship. My understanding from looking at argument and talking to Attorney Seddon was that it was something to the effect of picking up the son. So I did not think it was a grocery list or whatever, but the proffer that Attorney Seddon made to the court, and I believe that argument is in my appendix to the brief, is that it would depict an ongoing relationship. And the tension is that if there's an ongoing relationship, why would there be an ongoing relationship when these assaults occurred?
It appears to me at the transcript, page 2, the judge asks to see the text messages and reviews them, and we made his decision.
I don't believe. Again, I'm working off my
Page
notes right
107
here.
of the transcript. Maybe Ms. Mello can clear that up for us, but it's her turn.
I could, I know there's no rebuttal, so if I could try to get over to that. Just probably bear with me 1 second here. I'm trying to do too many things at once here. I think it'll just distract from the court's ability to conduct the argument.
The judge simply said during the preliminary hearing on the admissibility of the text that he'd like to review them before he made a final ruling, and he wanted to see them. There's just there's no indication, they clearly were not marked for identification or exhibits. So that's why they're not part of the record, but it appears as though the judge tried to review them, or at least had the gist of what they were from the argument. Is that correct?
That's correct. My understanding was he had the gist of it, and the gist was that there was an ongoing relationship between the defendant and his biological son about picking up, and the issue about exploring those texts. And again, if the court wants me to respond by supplemental letter, I can. But as Justice Lemire indicated, they do not appear to have been admitted before the court. And my understanding was that Judge Lang inquired about the substance, and attorney said and relayed what his views were.
And he simply said he was going to rule at a later time if the opportunity arose. The defense attorney never tried to introduce him at a later point, though.
Correct, Your Honor. It's not in an ideal procedural posture for appellate review, but I believe that the argument made prior to trial establishes what the defense intent was. The defense intent was to bring in the text messages to demonstrate this tension, and that they will be probative of bias. Admittedly, they couldn't go to credibility directly. There is a bit of a tension.
I think there's maybe an offer of proof here. I'm just looking at these pages. I mean, it is represented to the court that it's something about allowing the son to be taken to the defendant's home. So
I know we're, sorry, Justice Rubin. I'm looking at the assembly of the record on page 8. It says the printout of the texts were marked A for identification.
I don't know if they're in there, Judge. I pulled the file before the whole shutdown started. I've not seen the text beyond what Attorney Mellon provided, but I think it's fair to, I don't dispute the accuracy of what she offered. So,
and you received the assembly of the record from the clerk of the Superior Court, yes?
I did receive the assembly record. I don't believe I received the text.
Okay, your time has expired. I think we understand your argument better.
Thank you.
Thank you very much. We will hear now from you, Attorney Mellon. Perhaps you could shed some light on what's in the record and what's not.
May it please the court, Emily Mellon on behalf of the Commonwealth. Absolutely, I'd be happy to start with that issue. On page 8, note 6 of my brief, I talk about where Judge Lang asked to, as Justice Blake said, I believe it was Justice Blake, said that he wanted to review the text messages, and they're not marked necessarily on the record. He doesn't say anything about ID, putting them for identification A, but the assembly does show that they were marked for identification. And it's my understanding from that and from the transcript and from the context of the conversation and argument in the motion in limine on the messages that Judge Lang did in fact look at them. And that is why I included them in my supplemental record appendix.
Do we have copies that are marked Exhibit A?
I'm sorry?
Do you have, where are the copies marked Exhibit A? Are they in the trial court file? Are they, what did you use when you sent, did you just print out new copies?
Hold on a minute.
We've had this problem earlier today, I'm sorry. We've lost Justice Blake, but doubtless she'll be back shortly.
I've paused the recording.
Yes, we'll pause the recording, we'll pause the clock and make sure you have enough time. Attorney Mellon, I apologize for this. These things happen, but I know it's difficult to interrupt an oral argument.
Justice Blake is being admitted.
Thank you.
Second time today.
We're glad you're back.
Counsel, I'm very sorry. I don't know what's going on my end here.
We just have to get the clock back up, I guess.
So 14 minutes, because it was around 13:30 when Justice Blake.
disappeared.
That's fine.
The case is now being recorded again, and I will put it back to 14 minutes.
Thank you very much. Okay, Attorney Mello, if you want to continue telling us about what's in the record and whether there are copies marked Exhibit A that anyone's ever seen. I'm not sure it matters because there is a discussion in front of the judge about what the text messages say. Maybe that can be treated as an offer of proof. I don't know. But go ahead.
It's my understanding they were not marked as an exhibit. It's my understanding from the assembly that they were marked for identification. I think that there is, based on the transcript, I think that we can assume that Judge Lang looked at them. If he did not, then I put them in my supplemental record appendix. I thought it would be helpful for the court. It was certainly helpful for me. Those are the messages from our trial file. If the court does not want to consider the messages and wants to only consider the fact that there was, in fact, a message and the offer of proof given by the defense, I'm certainly, that is fine with me as well. I sought out the messages only because I was really at a loss at how to respond without seeing them. And I felt it was my due diligence to track down the messages.
All right, but you did not find them in the clerk's file. You obtained them through the district attorney's office resources.
That's correct. And I spoke with the trial prosecutor who confirmed to me that those were the text messages.
Would something marked only for identification make its way into the clerk's file ordinarily in this court? Do you know?
It might, and it's hard to say. It certainly could. The courts were shut down at that point. This was kind of the best way for me to get the text messages, was to review our own trial file, which was at my disposal.
We'll have to sort this out, but you can go ahead. I don't want to take more of your time.
Certainly, if the court would like to strike those text messages that I put in my supplemental record appendix from the record, I have absolutely no problem with that. I was just trying to
No, it is helpful, and we appreciate your efforts, and we understand the situation with the pandemic and so on.
In any event, I would argue that Judge Lang did not abuse his discretion in excluding the text messages, which are apparently, from my reading of them, one message between victim's mother and defendant's new wife, and another one between someone named Kaylin and someone else. And I'm not sure who those people are. They describe the fact that the defendant has apparently not contacted his biological son or picked up his biological son from a party. They were from January 2018. I honestly think that it's completely irrelevant to assessing the credibility of the victim, these text messages that came 5 years after the rape allegation. And in any event, any argument towards the fact that they shed light on the mother's understanding or belief of the victim's allegation is completely irrelevant, because the mother was not even the first complaint victim. The first complaint witness. The only reason that anything regarding mother even knowing about the allegation came out from the defense on cross-examination. First complaint.
Can I ask you a question?
Yes.
It's clear that as a matter of, it's clear the Commonwealth couldn't put this stuff in, right? It's clear you've got first complaint. We never even want to hear. And so I took her to the police because that implies believability. We have all this case law about it. That's clear. But if a defendant wants the jury to know this person who knows this defendant very well didn't even believe her, is that permissible or impermissible?
I think that it could potentially be permissible based on a cross-examination. And Judge Lang acknowledged that as well. He said, none of this will come in because it's not first complaint, but it's my understanding that you would like to bring it in because you believe that it is somehow advantageous to the defendant. The defense attorney said, yes, that's correct. And Judge Lang said, well, at this point, I'm not going to allow you to bring in the text messages, but if you believe that the door has been opened on cross-examination, I would invite you.
Didn't the judge preclude them from opening this door? This is the door of, did you believe her? And I thought that they weren't allowed to ask her questions about whether she found the complaint believable or not. I thought that was precluded. Am I mistaken?
Judge Lang had said that if the mother testified in a way that seemed to suggest that she believed the victim in some strong way or whatnot, that the defendant could come to sidebar and say, I believe the door has been opened. I would now like to introduce
but I
those
thought
text
that the defendant was precluded from asking that question. Did you
Well,
believe
I don't think
your
that the
daughter?
defendant can ask the mother, did you believe your daughter? I think that would be 100% objectionable.
Why? That's my question.
Because why is the mother's assessment of her daughter's credibility, that is completely irrelevant to in front of the jury. It is the jury's province.
It may be unfairly prejudicial.
Completely.
But it's not irrelevant, right? Here's this person who knows this child very, very well. The jurors have just seen her for a second. Now, I understand it's their job to assess her credibility. I'm not saying this comes in. I'm just trying to figure out whether it does or not. Your brother, I think, is conceding.
100% not. That would be completely objectionable. The mother could never testify about her assessment of the credibility of a child rape victim. It would be completely improper.
What is your
Absolutely
best
not.
case? Do you have a case that says that?
Well, I don't have a case that says that, but I would say that the defendant did not even try to do that, and that the judge did say, you may come up to sidebar if you believe that the door has been opened. And I think maybe he could have done that based on.
I'm sorry, go ahead. I missed that.
I believe that, she obviously knew, she obviously believed her because she did bring her down to the police station. None of that would have come in if it had not been for the defense bringing it in. That is completely inadmissible in the Commonwealth's case in chief. The defendant said that he believed that for whatever reason, that was good for his case.
So you
and
think
if
that
the defendant had at that point then gone up to sidebar and said, well, I believe the door has been opened because mom brought her to the police station and that shows that mom believed her, then maybe Judge Lang would have reconsidered. He invited the defendant to do that.
So you're saying that in fact, at least arguably, obviously I'm not asking you to concede this, the door was opened and they didn't bother to go back to sidebar and see if the judge would let it in.
I'm saying that the door could have been opened in cross-examination. Whether it was or was not is really not before the court, because it was not before the court below, because the defendant never sought to figure out
whether, if we were trying to figure out whether this claim were waived, whether the door was open or not might be important to us, right? Because if it was opened and they didn't bother to go to sidebar, then it's not right. One's a preserved claim, the one at the outset. And then if the door were opened, then it's not a preserved claim of error because they didn't go back to sidebar to try to introduce it. I think.
Sure, I would agree with that.
Okay. And she did testify in cross-examination that she took the child to the police?
Yes, she was asked about that.
Okay, I didn't realize that.
So, I mean, obviously none of that would have come in, but it did. And I think that Judge Lang invited the defendant to come back to sidebar if he believed the door had been opened, and that did not happen. I think under the circumstances, it was not an abuse of discretion for Judge Lang to exclude these messages at the motion in limine and say, if you believe the door has been opened, please come back to sidebar and we will discuss it. And that did not happen. There's no error. And if there are no further questions, I would rest on my brief.
Give me just a sec. I don't see any further questions, and I have none. Thank you very much. Very good arguments on both sides. We appreciate your help with the case, which is what you provide us. And the case is submitted.
Thank you, Your Honor. Thank you.
Thank you very much.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am pleased to be joined by, and you should be pleased that I am joined by, Justices Blake and Lemire, two outstanding colleagues. The rules for oral argument in this remote session, which we are holding remotely due to the ongoing pandemic, are the same as in our courtroom during live oral argument, which is to say 15 minutes per side, and there is no rebuttal. We've read your briefs with some care, so you may launch right into your arguments, although the time is yours, and you need not use all of your time if it turns out that your argument doesn't take all the time. The next case we will hear is number 20-784, Commonwealth versus Gonzalez-Santos, and we will hear first from Attorney O'Meara.
Thank you, Your Honor. Please, the court. Your Honors, this case is obviously was a duel of credibility between the alleged victim and the 50-year-old defendant. Defendant was more than 3 times the age of the alleged victim. As you know, I mean, from reading the case, I think it's easy to see that there was really no tangible evidence here. It was really, I mean, quite frankly, a duel of credibility from the testimony. Well, it wasn't even a duel because the defendant was, quite frankly, unarmed. The alleged victim.
Wait, can I understand, is it your argument that if the evidence is the victim's testimony that she was raped, that that's insufficient as a matter of law, that something more is required?
I don't think so, Judge, but I think, I mean,
because in your brief, I don't see what element you're challenging or what evidence you say is insufficient.
I guess, Your Honor, the root of my argument is that the judge, knowing that the credibility gap was huge, should have realized that. He should have realized that there was no tangible evidence. And he should have realized that if it went to the jury, there would have been a conviction. I think it's plain to see that in reading the case.
But the judge did direct out one indecent A and B, and the jury found him not guilty of aggravated rape.
That's correct, but he was found guilty on two of the counts.
But why shouldn't it go to the jury if there's testimony from a witness that he committed the crime? I didn't understand that argument either.
The argument is judges, that again, there was really no real evidence here. It was only testimony.
Wait. Okay, testimony is evidence, right?
Yes, I understand that, but no
And it's
tangible evidence,
real evidence.
no forensic evidence. There were no witnesses to this. And
there were two witnesses.
Well, there was no other witness testimony on the record.
No, I mean there were the victim and the perpetrator were both there, and the victim testified.
Yes, well, yeah, I mean, I guess I wouldn't call them witnesses. I mean, I would call them, opponents. So I don't know if I'd call them witnesses.
What would you call them?
They're opponents.
This is a criminal trial where the Commonwealth called witnesses.
Yes.
And the alleged victim testified as a witness for the Commonwealth. She was a witness.
witness to the assault by the defendant on her.
He was present and observed what happened, yes.
Yes. Okay, so I understand that. I mean, that's fairly obvious, but my point, Judge, is that it was only her testimony. She was her own
Yes,
witness.
But Justice Blake asked you at the outset, that's why she asked you, is your position that there must be something more than the alleged victim's own testimony? That there must be some forensic or other extrinsic evidence beyond that before such a case may go to the jury?
I think in this case, the answer to that is yes. I think there should have been more.
What's your best case for that proposition?
Well, I mean, if there had been another witness, if her sister had woken up.
I'm not asking you what other evidence would be good enough. I'm asking you, what's your best case for the proposition that the word of the victim alone under oath is inadequate to send a case to a jury? Do you have a case that says that?
I think it's, I mean, obviously her testimony was adequate. That was her side of the story. I agree with that. I'm not arguing that. So, you know, I'm not saying, you know, I needed something else. However, I guess what I'm trying to explain is that the judge, I think, should have been in tune with what was happening. Here you have a 17-year-old alleged victim on the stand, and she tells the story. She testifies that, you know, her this 50-year-old man walks into her bedroom, drops his pants, forcibly rapes her with her sister in the same bed. The parents were in the apartment. From just looking at the testimony, not commenting on it, I say to myself, if I'm in the jury box, I say to myself, and I know this goes to credibility, so I'm not arguing that, but you're in a jury box, you say to yourself, well, why didn't she cry out? Why didn't she do this? Why didn't she tell somebody? Why didn't she wake up her sister? So with that, I think, positive evidence, factoring in the huge credibility gap. So my argument is, I'm sorry, I'm trying to explain myself. I think the judge should have realized that and said, you know, this case, there's no evidence, there's no tangible evidence here. I can't let this go to the jury because it's guaranteed conviction.
Wait, it's guaranteed to be a conviction? I thought your point was it was an incredible story.
Oh, it was incredible, but he would have been.
Why is it guaranteed? Incredible stories don't usually get a conviction. They're not credible.
Well, that's what I'm saying. I think in this case, if for an outsider to look at this case, to look at the facts, he would have gone possibly through the same exercise I just went through. Why didn't, you know, he comes in, drops his trousers. Why didn't she say, what are you doing?
Well, there may or may not
follow
be
that whole thing.
But you're saying that it is so incredible, this story, that the judge shouldn't let it go to the jury. That's what you're saying. You're saying standing alone, it is so incredible that instead of letting the jury decide, is this true, false, partly true, whatever, that the judge should say no reasonable juror could find this happened.
Well, quite frankly, I would agree with what you just said. I think after you hear.
Well, I didn't say. I'm asking.
I you're suggesting, I should say.
I'm not saying that's what I think.
Well, your scenario, yeah.
Yeah, I don't. I mean, okay. I mean,
Attorney O'Mara, do you agree that the witness testified as to all the necessary elements of the offense?
Yes. Yes, that's correct.
And so your issue has to do with credibility only, which is the domain of the jury, correct?
That's correct. But you're you're all experienced jurists. So how does, I shouldn't be asking you questions, but in my mind, a jurist at a trial should see these things happening and sees the lack of evidence. Is able to separate himself and maybe say, this story is a little bit incredible.
But he did. He directed out one of the indictments.
Yes, but there was still a guilty, two guilty verdicts.
But if you follow my last questions
He
to
found
you,
guilty on count 1 and count 4. Yep, sorry.
Mr. Attorney O'Meara, the judge would direct out if the elements of the offense were not present. The jury determines the credibility, not the trial judge. That's the domain of the jury.
I understand that.
I mean, I have to say, we see a lot of these cases, sadly.
Yes, yes.
I don't see anything remotely incredible about this story. Now, I didn't hear the witnesses, so I'm not judging their credibility, but the idea that terrible adults commit sexual assaults on children, even when there's other children in the room asleep or nearby, I've seen an unfortunate amount of that, too much to think that it's not, that it's inherently incredible. It just seems like it's a jury question, what happened here, doesn't it?
Well, yeah, I mean, ultimately, it was a jury question, and the jury decided, came back guilty on 2 counts.
But why appeal that? I mean,
However, Judge, I think that based on the evidence, or paucity thereof evidence, and I understand that the elements might have been met if you believe the story.
but why? How does the judge decide whether she's lying or not? Look, if she said aliens came down, or and then all of my stuffed animals came to life, or you know what I mean, then it's like that doesn't sound like that maybe happened. But these are not facts that are completely implausible. They're terrible, but they're not implausible.
Yes, but I keep coming back. Yes, Judge, and I keep coming back to the fact that that even as things turned out, you have this young alleged victim testifying against an older man whose first language wasn't English. I don't think it would have been a good idea for him to testify on his own behalf. But anyways, that's beside the point. And I think this is inherently unfair prejudice that this defendant experienced because of this huge gap in age, this huge gap in credibility.
Huge gap in age. What does that do for us? Older men rape young women, sadly, every day, every week we see cases on appeal. So there must be a lot more actually in the trial court of older men raping young women. It's unfortunately, at least in the criminal justice system, quite common. I mean, do you think this, you think this couldn't have happened? I don't get that.
I'm not sure whether it happened or not, but I think that there was.
That's why it goes to the jury. That's why there is sufficient evidence, because you and I and even the trial judge hearing this person doesn't know who's telling the truth. That's the jury's.
Correct. Yeah, that's correct.
All right.
How do you? No. It's hard for me to get past the fact that just the way the dynamics of this whole case, the young, very 13-year-old victim and this 50-year-old alleged attacker, that in itself, the jury sees that. So I think this is the main point of my argument.
Well, you could have asked for a bench trial if you don't think a jury can do it, right? I mean, some people do in some cases. You're entitled to a jury trial, and there's a lot to be said for jury trials. I don't have empirical data on acquittals and convictions and age differences. And it's possible that the reason juries believe these stories is because there's no reason to make them up, or it's possible that they're just inflammatory. I mean, what are you going to do with a crime like this? That we have to have a system for resolving and punishing people who do this, and the jury system's the best one we've got.
I understand that, Judge, but I guess I would have felt differently about this case if there was anything else. So you don't have anything else. You have 13-year-old and a 50-year-old. That's what you have, nothing else. And you have her testimony, you have nothing from him. You know, and this dual credibility, he didn't even have a weapon. So that's my summation, I guess, is that it started off like this. She testified. It started off like this. She testified. The jury's looking at, hearing the testimony. They're looking at the defendant. They're looking at the alleged victim on the stand. That alone goes to the jury. If there had been one more shred of evidence, I guess my argument would be different, but there wasn't any evidence aside from the testimony. And I guess that's my summation.
So are you suggesting that that's true in any case and where there's maybe a child and an adult, even if it's not a sexual assault?
I think, yeah, I think the judge has to be sensitive to any case where you have that kind of dynamic. Yes, I think the judge has to be sensitive to that fact. And it's a shame. I mean,
and that the judge should override the jury's determination of credibility, even though there was evidence of the crime presented.
No, I don't think you can do that. I don't think you can override. I understand that's just.
Well, is that what you're asking us? Isn't that what you're asking us to do here?
Well, I'm just saying, for a practical purpose, if the judge could have said, you know, if I had any other evidence, I would have felt.
What if he committed the crime, Attorney O'Meara?
I know that's the unfortunate part, Judge. If you committed the crime, yeah, I understand that. And yeah, I just don't think he got a fair shot at this one. That's all I'm saying.
All right, your time is just about expired.
Thank you, Judge.
I don't see any other questions. Thank you very much for your argument. I think we understand it. Attorney Johnson.
Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. Here, the victim's testimony was thoroughly sufficient to withstand the defendant's motion for required finding as to the counts that were submitted to the jury. And as to the two counts where the defendant was found guilty, the victim testified on one occasion that the defendant pulled down his pants and put his penis in her mouth. And then on a second occasion, the victim testified that the defendant, while they were sitting on the couch together, grabbed her hand and put it in his pants and touched his groin and his penis. So that evidence was thoroughly sufficient to submit to the jury. And as the court pointed out, any credibility determination was for the jury, and the jury did in fact do so.
Attorney Johnson, can I ask you, in your brief, you also, I think you start out with the suggestion that defendant's brief does not rise to the level of appellate argument. If hypothetically I were to agree with you, do you still think it's important to reach the merits, or do you think we should decide it solely on whether or not the argument rises to the level?
I think my argument still stands that the argument in the defendant's brief did not rise to the level of appellate argument, especially as Your Honor pointed out, where we still don't know specifically what elements of these offenses the defendant claims were insufficient to submit to the jury. So I think here,
isn't just saying the evidence is insufficient, isn't that an appellate argument? It may be weak, but why isn't it an argument?
Well, I think because we don't know what element precisely we need to address here as insufficient. And I think in my brief I went through.
You don't think he's just saying there has to be something beyond the testimony of the witness?
Well, and I think if
that's a winning argument, I'm just saying, isn't that an argument?
And if that is the argument, I suppose it would be in the best interest for the court to reach the merits regardless, because I think that the argument that there needs to be anything else is not an argument that would carry the day, especially where these cases, and I cite to several in my brief, that have been decided based on testimony alone. And I think that here the evidence and the testimony was thoroughly sufficient to be submitted to the jury. And like I mentioned, any credibility issue that the defendant claims now was for the jury to decide. And they did in fact do that. They found the defendant not guilty on one of the counts of aggravated rape of a child. So to your Honor's question, I think even if the court finds that this doesn't rise to the level of appellate argument, I think if the defendant here is claiming that there should have been something more, it would probably be in the best interest to also address the merits, which I think are very clear that the testimony provided here was sufficient to submit the issue to the jury on the 3 charges that were submitted.
Do we have cases flatly saying in a sexual assault or rape case, no additional evidence is required? Have we ever said that sentence in a published opinion?
I don't think that sentence has ever been said, but I did find cases where victim's testimony was found to be sufficient to submit to a jury. So I don't think a court has specific, or at least I haven't come across a case that has specifically said that victim's testimony alone is enough to submit to the jury. But there are cases where that was the case and that was found to be sufficient evidence, if that makes sense.
Have you seen cases, I guess this sort of is not about this case, but have you seen cases where judges are kicking out sexual assault prosecutions because all they have is the testimony of the victim? Does that happen still?
I will admit I don't have a ton of knowledge on that issue.
Okay.
I apologize. It's not.
And what's your best?
A lot of.
What's your best case for victims' testimony only is sufficient?
Well, I have two, not just for that proposition alone. I have one for kind of each count that the defendant was found guilty for. So for the rape of a child charging oral rape, the King case, 445 Mass 217, and that was where evidence was found sufficient, where a male forced a female child to perform oral intercourse, and that was based on the victim's testimony. And then as to the indecent assault and battery, alleging that the defendant placed the victim's hand on his penis, the Davidson case, 68 Mass Appeals Court 72, where in that case, it was found that the defendant's conduct in touching, in inducing the child to touch his penis constituted indecent assault and battery. So those were kind of the two cases that I would highlight for the court on those two charges as to sufficiency. And if there were no further questions, the Commonwealth will rest on its brief.
I see none. Thank you very much for an excellent argument.
Thank
Very
you, Your
helpful
Honors.
to us. The case is submitted.
Thank you, Your Honor.
Five-minute break. Go one more.
What do you want?
Oh, wait, we're live still.
The fourth case is here if you want to.
You want to go one more, guys? That seems bad. Is that buzzing coming from?
Not me.
Oh, it stopped. Oh, something, Attorney Bancroft, at your location, I take it?
Not me.
I don't believe so. I was on mute too.
The case is being recorded.
Something, Attorney Bancroft, at your location, I think?
Someone has the audio on. Someone's live streaming.
Mute, too.
The case is being recorded.
You have to turn that off while we.
Someone has the audio on. I paused the recording.
Thank you.
Or maybe it was me. Apologies.
That's all right. Let us know when we're recording again.
The case is now being live streamed.
Good morning, everyone. Yes, it's still morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined by Justices Blake and Lemire. The next case we will hear is number 20-620, DCF and another versus Mother and others. It is an impounded case. I remind the attorneys not to use names and to comply with whatever other aspects of the impoundment order there are. You'll be more familiar with it than me, but we'll use words like mother, father, child, and so The rules for argument are the same, even though we are doing this remotely due to the ongoing pandemic. And those rules, the rules of the court, are 15 minutes per side with no rebuttal. I have been informed that the appellee's side will be dividing their time 7.5 and 7.5 minutes. Is that, and that the department will go first? Is that go first among the appellees? Is that correct?
That's correct, Your Honor.
All right, very good. We will hear first then from counsel for Mother, Attorney Bancroft.
Good morning, Your Honors. Allison Bancroft. I represent Mother. She is requesting that the court reverse the judgment, finding her unfit, and the decrees terminating her parental rights to her children. The judge's findings can be distilled into 3 main reasons why he found Mother currently unfit. Those findings do not support, by clear and convincing evidence, the conclusion. But before I discuss each of those in turn, I would like to just start by mentioning the relevant fact that by the end of trial, Mother was caring for her youngest child successfully. That child was 5 months old. She was in stable housing. She was not in any violent relationship. There were no issues as to anger management.
What is the record evidence about how long she had been in that situation that you've just described?
She entered detox in September of 2018. And she, I can find you the exact citations. She entered the Phoenix house shortly thereafter, also in September of 2018. And the trial itself concluded on May 30th of 2019.
And wasn't there some testimony or some evidence that Mother would likely have to leave Phoenix house within 2 months following the trial?
The evidence was that Mother would be transitioning out of the Phoenix house, and that the service providers at the Phoenix house would make sure that she would not just be sent out, that she would have stable housing thereafter. She testified to that at trial. So looking first at the first issue, the judge abused his discretion in relying so heavily on Mother's housing instability in order to find that she was not currently fit to care for her older 3 children.
I agree with you, counsel, that poverty cannot serve as a basis for terminating someone's parental rights. But is it accurate that the reason that she actually lost her public housing and was then precluded for a period of time from having it again was as a result of her behaviors and arguments and her anger management issues, to use the word that the judge used? And that was the basis for her loss of housing, not her financial situation.
No, and this information is included in my reply brief. The reasons that she was evicted from public housing was that she had failed to pay maintenance fees that were related to her stove being broken.
I thought there were also too many people in the apartment and noise or I'm mistaken about that.
She testified, there were noise complaints, and she testified about those as well. And she was asked whether or not she had tried to, work with the people who were in and out of her apartment to make sure that that was no longer occurring. And she stated that she hadn't paid the fees, so she was being evicted because of that, and therefore there was no sense in working anymore with the noise complaints because it wasn't the thing that she was actually being evicted for. And the social worker also testified during trial as well that she was told by Mother that it was failure to pay the maintenance fees that was the actual reason for her eviction.
So should the judge have considered at all that there were too many people in the apartment and that there were a multitude of noise complaints, or do you think that that was irrelevant?
I think that it was irrelevant that she was evicted because she failed to pay fees. After the eviction, obviously her financial situation is what made this 3-year ban from public housing such that she wasn't able to overcome her lack of stable housing despite her intense, repeated efforts to find private housing, to appeal the ban of the public housing, to enter shelters. There was just nothing that
Lack of housing the same as poverty, when the lack of housing is caused by poverty?
I'm sorry, could you repeat the question?
Is lack of housing due to poverty the same as poverty? We know that poverty alone cannot be used to terminate parental rights. But if due to poverty, a parent cannot obtain appropriate living space for a child, is that not a permitted reason to find them currently unfit to care for that child?
No, for two reasons. In this case, first, she was currently fit because she was in stable housing.
She did not have appropriate housing even at the end. She did have stable housing, but children can't join her there, or these children can't join her there. So she did not have appropriate housing yet, at least.
And she was transitioning into housing and was told that she would be able to obtain it, you know, she would be able to.
So my question is still, it's more of the, I'm asking in the abstract, do we have a case that stands for the proposition, if you can't get housing merely because of poverty, can you not be found unfit for having no appropriate place for the children? Because they do have to be someplace, right?
They do. And I don't have a case, but in this instance, where poverty made the situation in which she was unable to achieve housing within this 3-year period, and DCF couldn't even help her find housing, that there was no available housing for her, and it was based on the eviction that was caused by her poverty, and that housing instability continued also because of financial situation. It was an abuse of the discretion of the judge to rely so heavily in this case, particularly where the record is so clear as to her efforts to achieve that housing. And
Do we
all
know how much these fees were that she was unable to pay?
I believe it was a $150 fee for a repair of a stove. And she had been able to pay her rent, and she did so, but they added that fee onto it, and she was unable to pay that fee.
Because of something she did to the stove?
Because the stove was broken. I don't think there was any evidence on the record that she did something to the stove.
And the tenants have to pay to repair the utilities when they're not the appliances? Is that how it works in this housing? Do you know? Do we have anything in the record about it?
I don't know. I don't know the answer to that question. I just know the stove was broken, it was repaired, and she was assessed part of the cost of that fix that she was not able to pay. And because of the eviction, she was faced with a 3-year ban, and DCF told her to find a shelter, even though she was only eligible for one shelter of all the shelters. And all those shelters are only short-term housing. And so
even if we were to agree with you about housing, and it is notable that you don't claim that any of the findings are clearly erroneous, but we still have her criminal history, domestic violence relationships, anger issues with her visitation, probably secondary to alcohol and drug use, coming in and out of utilizing services. There's a lot going on here for your client. So even if we were to agree with you that housing perhaps should not have been the centerpiece of the judge's decision, and because you don't claim that any of the other findings are clearly erroneous, why isn't there enough here to support the findings in the decree?
For a couple different reasons. The other findings by the judge, even when put together, don't amount to clear and convincing evidence of unfitness. He did rely on alcohol and substance abuse, including the issue was with marijuana, when in fact she had not used marijuana for 2 years before trial ended, and it just wasn't a factor at the time of trial.
She did use it though when she was pregnant with the youngest child, right?
Right. The testimony was that when she found out she was pregnant, she stopped using marijuana. And that was in May of 2017. And the trial concluded in May of 2019. And she was tested throughout that rest of that pregnancy. It was always negative. The baby was born with no evidence of marijuana, and she was tested as well. So it just wasn't a current issue at the time of trial, and it hadn't been for years prior to the trial. In terms of alcohol, she had the short period of time which she self-reported in which she had an issue with alcohol. She went to detox voluntarily, and from there she went into the Phoenix house. So by the end of trial,
Was it in some way related to her relationship with this Mr. M?
she did say that he also used alcohol, and when she was with him, that's when the situation worsened.
And she hid her ongoing relationship, including pregnancy with his child, from DCF, right?
She didn't tell DCF right away as soon as she found out she was pregnant, but she did inform DCF while she was pregnant.
And didn't she intend to have some kind of ongoing supportive relationship from this Mr. M?
She had hoped that he would get his alcohol issue under control, but by the time of trial, she had no romantic relationship with him.
She wanted him to continue something, caring for the child.
Co-parenting.
Co-parenting.
She had hoped to co-parent, but then realized that it was not possible. And she was somebody that she relied on him for just very discreet instances where she needed a ride to court, where she needed diapers.
She had a baby with him.
She was pregnant when she ended the relationship. So he was pregnant. He was present at the birth, and there were these two other very discreet circumstances in which she asked for his help for her infant, and he gave them. But at the time of trial, there was no romantic relationship between the two of them, and no strong relationship. They hadn't seen each other since the birth of the baby in January of 2019.
Is that because she was in Phoenix house?
She had testified that there was no romantic relationship and just hadn't.
Yes, but I don't know if that's true or not. That's her testimony. But you say that she hadn't seen him. Was she allowed to see him while in Phoenix house? I would think no, but I don't know what the rules are.
There's no record evidence to that. I know, she did get money for diapers from him, wired. She didn't see him at the time. But I think the important thing to note is that she was not with him, and that their relationship, although there were certainly issues between them, it wasn't a relationship in which she was the victim of domestic violence.
She perpetrated domestic violence in it, right?
She admitted that she had slapped him and hit him on a prior occasion. And there was an issue that was raised in regards to anger management. That was another issue that the judge mentioned, in which she did take classes.
But right before trial, didn't she tell the social worker that she wanted to punch someone out?
She expresses thoughts and feelings, but the issue before the court, before the judge, should not be whether or not she's having feelings of anger, but whether or not she's acting on them. And the only instance recent to the trial was that she was in a verbal altercation with another resident that was de-escalated, and she became friends with that person. And I would argue that that's evidence of improvement. That's not a reason.
But that's in a controlled setting. Am I mistaken? At some point, didn't someone, I don't know if this happened or they just talked about it, did someone come over to her house to have a fight with her?
In the years prior to Phoenix House, there had been an issue with a...
And now she has recently still said there are two women she really wants to fight?
She has just expressed feelings. She has not...
That's not a feeling. A feeling is I'm angry at someone. I want to fight someone is an expression of a desire for a physical altercation with them.
But not acting on it is...
While you're in Phoenix House?
In anger... Well, when she was in Phoenix House, she did have an instance in which she was angry, and all she did was yell. And I would argue to the court that it's just not the type of anger.
All of this, the data is, this is a pretty small data set, right?
Well, we all see parents who are so angry that you could assume that they can't care for their children. They yell at judges, they yell at attorneys, they yell at service providers. This isn't that issue. She gets angry and now she's learning not to act on it. She's just expressing it. And I would certainly argue that that is not a reason to find her currently unfit and to keep her children from it. So looking now just very quickly at my final issue, I would just argue that, as I've been stating, mother wasn't currently unfit at the time of trial. If there was any issue, it would be temporary, that this was a woman who was on an upward trajectory. She had resolved a lot of her problems. She was resolving the rest of them, stable on her medication, really no issue. And for that reason, she asked the court reverse the decree and return her children to her.
Thank you very much. Your time has expired. Excellent argument on behalf of your client.
Thank you.
We will hear next from who? From attorney, you think I'd be better at this, Mazzone, of course.
Good morning, Your Honor. May it please the court. Dean Mazzoni, Assistant Attorney General on behalf of the Department of Children and Families. Absent any direction from this court, I'll try and address the issues in the order that my sister did and with attention to what this court considered important issues as best I can with the short amount of time that I have. But one overarching point I'd like to get across to this court, and I'd cite adoption of Elena, a famous case in these kinds of cases, or important case, cited in my brief, for the broad idea that past conduct is always relevant. Sometimes past is prologue, and a trial judge who issues thoughtful and comprehensive, detailed findings of fact and conclusions of law is it's well within the ambit of his or her discretion to say.
Can I interrupt you though?
Certainly.
And I know your sister does not claim that there are any clearly erroneous findings, but it strikes me that as to the statutory factors, particularly 210(3) little 3, there may be an issue with respect to his application of at least the preconditions of that factor, because there was meaningful contact. And I didn't get a chance to ask your sister this, but there was meaningful contact between the children and the mother. So let's say we agree with her argument, and that is that the judge inappropriately applied that factor. How does that change the analysis or the decree?
I think my brother, I believe Mr. Campbell, addresses this issue head on in his brief and does it well. I think it's one point of fact that may or may not be erroneous, but it's very marginal. The judge, in fact, found that there was a bond between the mother and children, such that she's going to receive post-termination visitation rights, and I think in that sense, I think that disposes of that issue, and I do think it is marginal, respectfully, which is the term my brother used, and I agree with that. Going back to my point, where a judge views a continuous history of a life that goes in cycles, as this case, as the mother's case, the mother's history shows in this case, which is that periods of sobriety followed by periods of relapse, periods of calm followed by periods of violence. The judge in this case just could not be confident that the several-month improvement that my able sister cited was going to be permanent. In fact, that would be contrary to the mother's history and to the cycles that I just described. And the judge was well within his discretion to not have that confidence and make this very, very obviously important decision to terminate the mother's parental rights without her consent. But he had an incredibly strong basis in the record, and it's well documented in his findings and rulings. As for the issue about poverty, and as Justice Rubin talked about, and whether or not that is relevant to a home situation, this court said, I know you can cite the unpublished opinions now, from, if I'm not mistaken. But
If you attach them to your brief, but go ahead.
fair enough. This court has said that no, it's not. You're not penalized for being poor. You're not going to be penalized for not having the money to do X. Nonetheless, the children need stability. The children need a home. And if the lack of resources contributes to that, that's something the judge still is faced with and has to deal with. And that the termination of parental rights may still be appropriate in those circumstances. So I think that's a fairly straightforward answer to a very important question that Justice Rubin raised. Her history has shown that she herself, the mother herself, could not find a stable home for herself. And she couldn't maintain one for the children. And that's what the children are entitled to. And the judge was well within his discretion to say it was in the best interest of the child to terminate the parental rights. And going back to the issue of the eviction, I think there's evidence in the record. It can be read different ways, but it's certainly supportable for the judge's finding to say that yes, there was the maintenance fees issue. I'm not well versed in what the prison has to pay or not for the stove, which my sister mentioned, which is correct. But nonetheless, there was also evidence about too many people in the room, a lot of noise. And that the record can be read as that being one of the reasons why she was evicted. It can be fairly read that way.
So her financial situation could be part of it, but you're saying it wasn't the central piece. There were other factors.
Absolutely. Yes, Your Honor, I am. And also the lack of resources is something a court has to consider and is perfectly justified considering. If the money situation leads to is one factor that leads to the parent being unfit by clear and convincing evidence, then that's something a judge can't avoid and can't turn his or her head from. And the judge did not do so in this case. So I wouldn't say so I would leave it there and say that the lack of resources is something to be considered, and it's really the issue of financial stability and housing stability that is crucial in a case like this. The mother's relationship, I'm running out of time. I've totally hit my high points. The mother's relationship with Mr. M, very recent. The anger issues, in my opinion, I mean, recent is just a label, but not too far in the past for the anger issues to manifest itself in some admittedly disturbing violence perpetrated by the mother, admittedly. And as I write in my brief, and as this court said, so I won't belabor it, to say, she stopped actually hitting people, but she still thinks about it a lot and has these feelings is really cold comfort for a judge who's in this position where he has to make this important determination for the lives of the three children. So my time is running out, and I want to leave my time to my brother, Mr. Campbell. Is there any issue that the court has that I can be helpful to in 4 and 39 seconds? Okay.
I see none. Thank you very much. Very helpful argument. We will hear now from you, Attorney Campbell.
Good morning. May it please the court. My name is Alan Campbell, and I represent the 3 minor children in this case. The minor children ask that this court affirm the judgment below.
Can I ask you when you most recently had communication with the children themselves, if you have had such communication?
I saw them last week. That's actually one of the wonders of Zoom, is it's very easy to get in touch with children clients, and they're familiar with Zoom. So the meetings go very well. They're used to it.
How old are they now?
They are, 1 second, I give you the exact ages. They were born in 2008. Oops, sorry, wrong one. They are 3, 6, and 11.
I see. And do they remain in the same pre-adoptive home they were in at the time of trial?
Yes, the 3 of the children are in the same pre-adoptive home.
And it remains a pre-adoptive home, that is?
It remains a pre-adoptive home as well, yes.
Thank you.
So if I could address the question of why mother was evicted. I think the record is actually clear that she was evicted because there were too many people in the home and noise complaints. At page 481, lines 4 to 10, mother describes the magistrate hearing at the housing court. And that's what was discussed, that there were too many people and that there were noise complaints.
What volume are you in, counsel?
It's the trial.
The transcript? Okay.
The transcript volume, rather.
Volume,
So,
okay.
yeah, page, again, 481, lines 4 to 10, mother discusses it. Mother does later, I believe it's the next page or 2 pages later, she does say that she had missed a fee for a stove and that she assumed that she was going to be evicted anyways. But it appears that the actual eviction was too many people in the apartment and noise complaints. And not paying the $150 really isn't a poverty issue. Mother was working. She was using marijuana every day and using alcohol nearly every day. She decided to spend her money on marijuana and alcohol rather than the $150 for the stove.
Well, we don't know enough about what she spent on marijuana and alcohol. I mean, I thought about that too, but we don't know what her expenses were exactly.
We don't know exactly, but we do know that neither of them are free, and especially now that marijuana is legal, the prices are easy to determine, and it's not free. But I would just say, even if it was free, it appears that she was evicted not because of not paying $150.
I understand what you're saying. We'll look at that, of course.
And then as for the argument that mother now just yells at people, the judge's role is to weigh the evidence and make determinations. As recently as I believe it was 2018, mother had given Father M a black eye on one instance, and another instance had struck him hard enough that she broke her fingers. There were fairly recent incidents where I believe Father S, where they had an argument on Facebook, and Father S suggested he would send his sister to have a fight. Mother said, that sounds great. They came over, they had a fight, and mother described it as very mutual. And mother testified that she had been arrested, I believe it was at least 6 times for assault and battery. So it's certainly within the judge's realm of reasonable decisions based on the evidence before it that mother was still a volatile person. And I believe mother's argument that she was stable overstates the evidence. She had been in the home for, I believe it was 2 months at the start of trial, and then 8 months by the end of trial. And she was relatively stable in Phoenix House. That's certainly true. She had one room that she had to maintain, one child. She had lots of services in place. And even with that, she was unable to maintain a rule. She was written up. So she was violating the rules for the way she was keeping her room. She was also written up for conflicts with other residents. And the staff at Phoenix House expressed concern that concerns as to whether mother would be able to maintain her stability once she was back in the community. And that was planned to happen based on mother's testimony sometime around July. So just shortly after trial ended, mother was expected to no longer be at Phoenix House. And I think Ilona is a good case for this, because even when a person is working with services and showing some progress, it's the court's job to weigh all of the facts in the case, weigh her history, and determine whether or not that progress is going to be temporary or not, or whether she's likely to revert. The mother has approximately a 25-year history of substance abuse. It's great that she was sober while she was in Phoenix House, but it was perfectly reasonable and certainly not an abuse of discretion for the judge to find that sobriety was not likely to continue indefinitely.
Is Ilana the case that discusses the need for stability for the children and balancing that with the parent's right to parent?
It could, Your Honor. I did not cite it for that proposition, but
Okay.
there are, as you know, there are many propositions in these cases. They don't just do one issue per case.
Right.
If I can just go through, I think I've actually covered everything, but if I could just take a moment to look at my notes. Yes, briefly as to factor 3, as Justice Blake mentioned, and as I argued or put in my brief, that factor was not entirely appropriate. The factor little 3 has 3 components: that the children were in care for 6 months, that the parent did not accept or benefit from services, and finally that there was a lack of meaningful contact. The first two apply to this case, and in the judge's discussion of that factor, the judge mentions that the children were in care for 6 months and that mother did not benefit from services. There's no mention of a lack of meaningful contact, and in fact, the judge found that there was meaningful contact and awarded post-termination and post-adoption visitation. But this was not the only factor, and it was not even really a significant factor. There were 9 factors that the judge found relevant. So even if you take this one out, there are still 8 of the statutory factors that the judge found relevant for which there are no errors. So unless there are any other questions, I just, again, reiterate the children would like this court to affirm the judgment below so that they may be adopted by the home that they've lived in for the past several years. And for any other points not addressed here, I will rely on my brief.
I see no further questions. Thank you very much for your argument. It was very helpful to us. These are always tragic and difficult cases for us. So we very much appreciate all 3 of you assisting us with your arguments. The case is submitted.
On when the other party is making the presentation.
You can if you like. I mean, that's probably, I mean, you're less likely to have some errors.
Thank you, Justice.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined, and you are joined, by Justices Blake and Lemire. The rules for argument on this remote session, which is being held remotely due to the ongoing pandemic, are the same as the rules in our courtroom, which is to say 15 minutes per side and no rebuttal. The next case is number 20-626, Kelly versus members of the MASHPEE Zoning Board of Appeals and others. We have read your briefs and are familiar with your arguments, with the facts of the case. You may want to get right into your arguments, though it is your time to do with as you wish. And I believe we're hearing first from Attorney Nyland. Is that right? Yes.
Yes. Thank you, Justice. May it please the court. This matter, as you know, involves the appellant's appeal of a lower court ruling granting summary judgment and affirming a special permit allowing a cottage to be raised and replaced in Mashpee. At the outset, I would say the appellant is not arguing that the appellee is not entitled. He clearly is entitled to raise and replace the cottage. The question is whether or not the replacement of the cottage should include a lean-to / carport that is attached to the building. So
do you say that that's a question of fact or a question of law?
I believe it's a question of fact when I look at the definitions, and I know that the court has said that when there's a mixture of fact and a question of fact and a question of law, that it's determined to be a question of fact. The bylaw references dwelling structures, and there's a leap that's made, again, which I believe is a factual leap, from the unenclosed carport as a structure then becoming a building, and then the building then becoming part of a dwelling. So I think that those are factual questions. When you take a look at the definition of building, it states that structures are included unless it's unequivocally inappropriate out of context. And I think it is out of context, because what this does is it allows this unenclosed storage area, which has no tie to the house. There's no
Let me ask you this. I find this bylaw a little, it's not opaque so much, it's just ambiguous. Do you think an attached garage could be part of the dwelling house, or is that an accessory building?
Well, the bylaw, and I include this in my papers, considers a garage to be an accessory building, an accessory use.
Accessory use and accessory building are not the same.
I agree, Justice.
And there's some conflation of that in the briefing here. I'm just trying to figure out, I mean, I'll tell you what it looks like to me, and I'm not sure what to do with this. It looks to me like this could be classified as either one. It seems to me that it's a question of law, which it is. And on the one hand, you could say, well, this is an accessory building. They don't need to be detached. And so it's an attached accessory building. Or you might say, well, it says that every part of the structure attached to a building is part of the building, and it's certainly a dwelling building, and this is attached to it, part of it. It looks to me like you could construe the bylaw either way. And, you know, so I wind up thinking about two things. I wind up thinking, well, should we just defer to the ZBA's construction? That's one thing, I think. And then maybe the more important thing, I think, is what keeps the ZBA from telling the people it likes, oh yeah, this is part of your dwelling structure. So you actually, the prior conformity, nonconformity is very near the property line, and telling people they don't like, I'm sorry, this is an accessory building attached to your house and you can't count that.
I agree, Justice, that it is opaque or it is ambiguous, and that's the problem that we have here. When we take a look at the decision from the ZBA in terms of deferring, I don't see any findings relative to whether or not it's an accessory building or it's part of the dwelling.
Well, it has to be implicit, right? They do say where the prior nonconformity went to, and they include the footprint of the carport. So they must be concluding that it is not an accessory building, but rather part of the dwelling. Otherwise, it wouldn't work that way, right?
Well, yes, other than approving the plan, there's no written findings that give us any indication of how they're feeling. And to get to your point as to whether or not somebody that they may feel comfortable in assisting as opposed to somebody that they're not going to assist.
Well, we could publish a decision saying that MASHPEE has construed it like this, and this is what it means, and this is what it means forever and ever. And, you know, and they can be stuck with it. You know what I mean? That might ensure uniformity of treatment in the future. Anyone in MASHPEE will find that decision the minute they're looking to use the raise and replace rule.
Yeah, I'm not sure that in this, that would be applicable to all instances. That's the difficulty here, is because we have a unique situation where we have this carport that's that doesn't demonstrate any other indicia of being a building. It's clearly an accessory building, if anything, but it's not habitable. You can't.
I mean, it doesn't have its own wall, right? So it's not, I mean, I don't know that an attached accessory building, right? Townhouses have shared walls. This has a shared wall, if you think of it that way, right? It at least isn't another building right glued onto it with its own wall. But neither is a garage, I suppose. A garage might be part of the dwelling house. Seems to me it probably would be, but I don't know. I don't know.
Yeah, well, I think that's why we think that that's a question of fact, Justice, and that's.
How can it be a question of fact?
Well, because if the bylaw definition of building is generally related to enclosed three-dimensional structures, and we don't have.
Not any structure is then defined as, like, I don't remember, anything that supports something or shelters something, or, you know, anything with a roof on it. Seems like it's a structure and maybe a building.
Unless unequivocally in context, it doesn't make sense to have, and that's what we're arguing here.
But how can it not make sense to say not make sense? I just can't see that it couldn't be part of the structure, given the, you know, the language about all the parts of it, you know, all the structures connected to it or whatever. I don't know. it's not clear to me that it's natural to call that thing a building, right? It's not really, I mean, I understand building includes structure, but it's not a building, right? It's 4 posts or 2 posts and a roof.
I think, Your Honor, you're agreeing with what our position is, and this is why we think it's unjust enrichment. It's not appropriate for the appellee to take advantage of this non-building, which is classified as a building by semantics.
No, I think if it's not a building, I don't think that does help you, because it's either part of the dwelling or it's an accessory building that's attached, right? It's one or the other.
I believe it's an accessory building and it's not part of the building. In terms of sharing a wall, yes, the wall, the exterior wall of the house is the only interior wall, and there's nothing else that links the two of them. It's shingled, and that's the extent of it. So as an attached building, then what makes that part of the dwelling? That's the leap. The issue is not whether it's an attached or accessory building.
You begin talking about why a deck is and a carport isn't, and I don't know. You know what I mean? Maybe they leave their case of soda out in the carport, and they walk out the front door to get it when company comes over. Maybe they, you know what I mean? So it's sort of like a closet. I don't know.
Well, a dwelling as defined in the bylaw is intended for habitation and for those uses. And I think decks certainly are tied to the house. They're either sliding glass doors or they're doors. And so there's habitation that's taken.
But attached garages sometimes have a door into the house. Sometimes they don't.
Well, again, I don't believe that this constitutes a garage. It's a garage is enclosed.
But enclosure doesn't seem to be in the bylaws. It talks about shelter, not enclosure.
Well, again, I think where we're getting back to is I believe that these are questions of fact rather than questions of law as to whether or not that specific structure, accessory building, whatever we may call it, is entitled to be considered part of the dwelling structure. Because that is the consequence of that determination allows them to enlarge the structure that they're building. It takes the 996 square foot cottage and allows them to go substantially larger. And
it's going to go substantially larger anyway.
Yes.
Right. It's going to be a 2-story, much more serious building after the raise and replace than it is before, wherever the edge of the building is.
Right.
That's allowed.
Well, that's allowed. It's a matter of right. They could do that if you just use the existing footprint. But what they elected to do was to go under this raise and replace. So we have a 12-foot encroachment from the carport, which is now going to be extended 40 feet on Seaview Avenue and go 2 stories. So by calling the carport a building and part of the dwelling, when it has no habitation at this stage, allows them several hundred square feet that they wouldn't otherwise be entitled to. So it becomes an important decision, and that's why it's an important factual question for the court.
And what is it that you say is the fact rather than law?
I think the fact is whether or not that accessory building is part of the dwelling structure.
Why isn't that a legal question about the definition of dwelling house or whatever the phrase is?
Because I don't think that I think the definition of dwelling relates to habitation, and there's nothing in the pleadings that references any habitation that's taking place or anything normally associated with dwelling for the court to look at. That's why I think that we need to review the facts associated with how that structure works and why it was constructed, and go into what its functions are and compare that to what functions are within a dwelling. That's why I don't think it's like a deck. I think it's far different than a deck. This is just an attachment. It's like a lean-to that they put on the house, and now they're taking credit for it as part of the dwelling.
Well, the picture shows it as being cohesively connected to the dwelling. The roof comes down in one solid line. The walls of that are enclosed are part of the house, so it's connected. It's if you look at it, you wouldn't say there are two different structures there. I would say there's one structure.
I think that
it's part of the. I don't separate it from the structure, so it's part of the dwelling structure.
Well, we do have shingles, as you can see, and you're correct. The shingles attach from the house onto this accessory building, and it uses just one side of the house as a wall. It's not enclosed. It's a gravel floor. There are columns that are on cinder blocks. So it doesn't bear any other relationship to the dwelling other than to being, as I see, incidental to the primary use. So it would be an accessory building. I don't see it as part. I don't see it as part of the dwelling. So
awfully tough case.
Well, I again, I think that it's a very limited question, justices, because and there is deference that goes to the ZBA, but I don't think the deference is necessary here because I don't think that there's sufficient reasoning or findings within that decision to lead us to anything other than implied version. And with respect to the lower court, I believe that the lower court considered that to be a question of law rather than as a question of fact, and that's what we disagree with, and that's what I believe our papers have explained, that that's a question of fact rather than a question of law. Are there any other? I can't see if my time is closing.
You've got 9 seconds left. I see no further questions, so I think we understand your argument. I think it's a very interesting case. It seems like a very close case to me, and luckily that's why we get to hear from both sides. Mr. Corain.
Morning, Justices. Again, Attorney Christopher Corain representing the appellees. And, we've maintained that, 2 points. One is that this is absolutely a question of law, and it's based on the fact of the interpretation of the bylaw. As the justices have had various questions, there's perhaps some ambiguity. Ultimately, that ambiguity should be resolved by the Zoning Board of Appeals, and they've determined that. And the deference should be.
If this was a traditional garage that's attached to a house, all sides covered, a door, we wouldn't be here, right?
That would be for Attorney Nyland, but I'm guessing he probably would not be here.
Okay, so what about something like a shed?
A detached shed?
Detached shed.
I would not believe that you would be able to benefit from if that detached shed was in the back corner of the lot, I don't believe that you would be allowed the benefit of that setback. But I don't think this is not a detached shed. The pictures themselves, you can't just take this carport overhang and remove it from the building. It's intimately, as the trial court judge said, it's intimately integrated within the structure and within the building.
But do you agree that an attached accessory building is permissible under these zoning rules, that there is such a thing as an accessory building that would not be, I suppose, part of the dwelling, and it can be attached? So what the heck is that?
So, yeah, there's a definition of detached dwelling in the bylaw that says a building designed or occupied as a residence and separated from any other building except accessory buildings. So, again, but I don't think that undermines my argument. If the bylaw allows to have it.
Okay, but then doesn't it require us to determine or require the zoning board of appeals to determine, or require someone to determine whether this is in fact an accessory building that's attached, or I was looking for the definition a second ago, or all parts of any kind of structure above ground of the dwelling building.
But again, I think to two things, or one thing to that, Your Honor, I don't know that that distinction needs to be made. Ultimately, the Board of Appeals, as Your Honor noted earlier, they granted the permit. So, and these arguments were made by the appellant at the zoning board level. So it's not like this is the first impression. So the board certainly heard those arguments and dismissed those arguments by giving them the permit. And again, secondarily, I don't know that it matters because the raise and replace bylaw does not distinguish between accessory and principal buildings. It just says a dwelling structure.
Whoa,
and then I think that this certainly falls within a structure.
You just said that an accessory building would not move the nonconformity to where that building is. So it does make a difference if it's an accessory building or not. Or you think once it's attached, it does. I would have thought an accessory building doesn't move the footprint and that part of the dwelling does. And then maybe we defer to the conclusion of the board. That brings me to my next question, which is what keeps the board from calling tomorrow's carport an accessory building and not giving the owner the benefit of that? Because they don't.
I think it's the standard of review, arbitrary, whimsical, capricious. I think if somebody were to come before this board and say, last week you gave these, you identified it this way, and then you're identifying a different way, to me, that's arbitrary and capricious. There's a standard that can be applied.
Well,
I think that's what.
Are these carports, I did note that your office is in Mashpee. Are these carports typical, and do we know of any other ZBA cases addressing this issue? Maybe they haven't gone up, but in terms of the application of the bylaw, are you aware of anything?
I'm not aware of any other zoning board decisions regarding carports. I don't want to.
No, that's fair.
I don't want to misrepresent. Carports exist. I mean, I've certainly seen them before. Whether they're common or not, I don't want to represent one way or the other. But and again, I'm not aware of any ZBA decision on the specific on the subject.
I think a carport has multiple definitions or multiple appearances. This is, the picture that's in the appendix shows a house that's it's one structure that has ability to either park or store things underneath the front edge of the roof.
Yes.
If that were a garage with a garage door, we wouldn't be concerned about whether that was part of the dwelling structure. It's not a separate carport that's a separate building next to the house, but it's the rafters seem to run, the roof rafters seem to run right into the house and connected. It's not a separate, you can't sell that as a separate unit. Like, here, I'll sell you my carport. It's attached to the house.
Right. And,
So
and as I said, you're right.
it just seems to me the simple understanding is it's a part of the dwelling structure.
Right. I agree 100%, Your Honor. And as I said at the beginning of my presentation, you can't just take this overhang off of the building without doing detrimental damage to the integrity of the building. And I think I want to go back just to point out when I don't think that this isn't an accessory building like a shed. It is part of the structure. If these posts weren't there, it'd just be an overhang. And so I think it's really difficult. There is no definition of a carport. The appellee defines it as a carport.
If it was screened in, it could have been a sunroom for the house.
Absolutely, Your Honor. Absolutely, Your Honor.
Connected to the house.
I treat it as a deck, or a garage.
Is there any entryway into the house from the carport, or you have to go out of the carport and through a door somewhere else?
I believe that you have to go outside. I don't believe there's an interior doorway.
Do we know anything about how garages have been treated by the Zoning Board of Appeals?
That would be a great question for my father, who does a lot of the zoning in Mashpee. I believe that they're treated as, I believe they're treated as part of the structure. I know that the bylaw defines them as a quote unquote accessory use, as Attorney Nyland points out, but I'm not aware that when somebody knocks down a garage, that they treat it as, creating a nonconformity. A lot of times these in Mashpee, especially these knockdown replaces, are of old 1950 cottages, that don't even have garages.
Sure.
But, again, so, I think it squarely falls within a question of law, and you have unfortunately, all these multiple definitions where, structure fits into building and building fits into the raise and replace. And, again, I think that, this certainly qualifies, as a structure, and the raise and replace says dwelling structure. And, I don't think that the board was arbitrary or capricious or whimsical or unreasonable, and that's ultimately what the legal standard is. And if you look at the pictures, I think, Justice Lemire is absolutely right. It's integral to the structure itself.
Didn't I read, I can't seem to locate it. I thought I read that the board had treated similar situations similarly in the past. Was that in the materials? Do you know what I'm saying? There was some reference that the board had treated something similar in the past, or had treated them similar, other situations similarly.
I don't know that I made a representation in my materials to that, Your Honor.
Okay.
But I'm not aware that certainly I'm not aware, of any ZBA decisions or any appeal decisions, of the Mashpee bylaw. Unfortunately, this raise and replace bylaw is relatively new. It was only adopted within the last 2 to 3 years. But, I know it's a unique situation, but, ultimately, I have to fall back on the fact that, there was a hearing before the Board of Appeals. They were presented with all this evidence, and, discretion should be afforded to the board in that regard. And then that was appealed to the land court, and the trial judge agreed. And, there's some deference to their findings as well, findings of fact, unless they're clearly erroneous in that regard. And putting it together, looking at the definitions and looking at the photographs and the evidence, I don't think there's anything unreasonable about what was found by the board. The board found the other standards to be met, not substantially more detrimental to what was there before. Has the parking. We went through conservation. We went through the Board of Health. So this checks all the boxes of something that, was not unreasonable to be approved.
Have any other abutters raised a concern?
I believe Attorney Nyland represents, I think he represents 2 abutters. I'm not aware that any other no one else, only the parties that have appealed it. No other,
Okay.
Parties were part of the appeal.
Just want to make sure there wasn't some other panel hearing this exact issue.
Oh, not that I'm aware of, Your Honor. And as far as, I feel like I have to take up my time. I guess I don't need to, but I don't have 3 minutes left. But
We have your brief. I think we understand the arguments
Right.
here pretty well. You don't need to, it's your time. You may use it, but you shouldn't feel like you have to.
Right. Yeah, I mean, I think, conclude, I think, obviously you have my brief, you have my argument, you understand what the issues are. I think that, ultimately the board made a reasonable decision based on, what's there on the ground. You look at that carport, it's integral to the structure. And I don't think there's anything unreasonable by concluding that the nonconformities go from there. You're not creating any new nonconformities in that regard. Just seeing if there may be anything else. Judge Roberts did a good job of, explaining this as well in her decision. I don't think that there's anything that I necessarily have to add unless there's any additional questions from the justices.
I don't see any questions. I think we understand your argument and your brother's argument. And as I say, it's an interesting and oddly complex case. So we very much appreciate both of you providing us with assistance in sorting through it. The case is submitted.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Blake and Lemire. The next case we will be hearing is number 20-588, City of Lawrence versus Firemen'S and Oilers Local 3 SEIU. The rules for argument when we do this remotely, as we are today due to the ongoing pandemic, are the same as when we sit in person. Each side has 15 minutes and there is no rebuttal. We have read your briefs with some care and are familiar with the background to the case, so you may want to get right into your arguments, although it is your time and you may do with it as you wish. We will hear first today from Attorney McKissick.
Good afternoon, members of the panel. May it please the court. My name is Paige McKissick. I represent the appellant in this matter, Firemen and Oilers Local 3 SEIU. This case concerns a 40-year DPW employee who was discharged by the City of Lawrence in 2017. The issue on appeal is whether the Superior Court improperly vacated a labor arbitration award reinstating his employment under the so-called public policy exception of Section 11, Chapter 150C. The standard of review is among the narrowest in the law. I think the Superior Court clearly recited that standard, but did not apply it in this case. I think it's clear from the Superior Court's order that the judge was not satisfied with the arbitrator's factual findings and legal conclusions, so much so that she actually remanded the case to the arbitrator for more factual findings.
Is the propriety of the remand before us?
Your Honor, no. I don't think it is. I don't think it was properly. It was not appealed. Neither party appealed it, and also under Section 16 of 150C, I don't think there were grounds under which it could have been appealed.
And I think that your position in this appeal is, assuming without deciding that that was fine, you still win.
Yes.
Right? That's the whole, you don't challenge that. You're not saying it's no good, and so whatever.
Your Honor, that's correct. Notwithstanding the issue of the remand, the Superior Court engaged in factual finding and made legal conclusions that were directly contrary to those of the arbitrator, and that's simply impermissible under the law. I think she did that. The judge did that in an effort to apply this public policy, which in our view does not exist. There's no case that establishes a public policy against retaining employees who repeatedly engage in disruptive behavior. I kind of see it as articulating some kind of problem employee policy. And it's just a construction under 150C of a public policy that's impermissibly broad. It would be the exception that swallows the rule. As the SJC said in Pittsfield, it would turn arbitration into just a step between a grievance and litigation in the courts. And that was not the intent of 150C.
Well, can I slow you down for a minute? So section 11A3 says that there are limited grounds for vacating an arbitration award where, quote, the arbitrator exceeded their power or render an award requiring a person to commit an act in conduct prohibited by state or federal law. So you're not saying that there isn't an exception. You're saying that it's a limited exception and that it's not this public policy exception that Judge Fahey seemed to create. Is that your argument?
My argument is that the Judge Fahey sought to vacate or vacated this award under the public policy exception of section 11A3 by creating a public policy that doesn't exist, and then applying it, and in doing so, also making her own factual findings.
Okay, so you cite City of Pittsfield in your brief and the three-part test. So it's not that a public policy exception doesn't exist. It doesn't exist in this case.
It's that there is no public policy to apply. The public policy that the judge articulated is not one that has been established by any prior
So
case.
can you give me one that would apply, just in terms of contrasting your facts?
Sure. I mean, you know, there are clearly established public policies by cases like Geller, which establishes a public policy against the use of physical force by teachers against their students. That policy was created by reference to statutes and regulations against corporal punishment.
Okay.
That's pretty clear.
I take it your point is there is no such thing as the public policy exception. There are exceptions to this where a public policy requires a different outcome, but before one can find such a public policy, it has to be clearly defined by reference to hopefully clear extrinsic legal authority like statutes, regs, longstanding something, more than it's a good idea to fire bad employees.
Yes, Your Honor. And I think the public policy that the Superior Court relied on in vacating the award, which again, we don't think exists, if it did, it would task courts with making the kind of equitable determinations that arbitrators make all of the time. That's sort of the bread and butter.
And it would require employers to fire employees in myriad circumstances where they don't now.
Yes, and then all of those decisions would be subject to judicial review under Section 11, and that it's just too broad of a construction of the statute.
Couldn't there be a broad public policy that the municipality is not required to keep insubordinate personnel? And so that there being maybe such a broad public policy, but here under the application, even under the case law says, but the dismissal would have to be required under these circumstances. In other words, although there might be a broad policy that you don't have to keep insubordinate personnel, there has to be some reason other than that to justify a dismissal. So in other words, the contract would say maybe after 4 incidences of insubordination, they're subject to termination. So, I mean, the highway case that's cited extensively stands for that proposition that it requires a showing even with a policy that the dismissal was required. So isn't it simple to say, even assuming there's a broad policy here, the dismissal wasn't required as determined by the arbitrator?
Yes, I think that's right. And you're referring to the third prong of the test. And I would agree, although, you know, I don't think that there can be a public policy against, you know, retaining insubordinate employees, because it would upend, quite frankly, the system that's in place that defers to public sector collective bargaining and labor relations. But that being said, with respect to the Mass Highway Department case, I want to be very clear about what that case was talking about when it referred to malperforming employees. That case does not stand for the proposition that there's a public policy against malperforming employees. The Superior Court, in essence, sort of cherry-picked that language out to support the public policy. What the court was saying when it used the word malperformance, it was talking about the second prong of the test, which looks at whether or not the conduct that the employee engaged in was integral to the performance of their job duties. And so the use of the word malperformance refers to the conduct that violates the public policy. Doesn't stand for the proposition that there is a public policy against malperformance generally. And again, I think that would be far too broad of a policy.
And was that the case that was tied to safety issues?
That was the case of an employee, a highway officer, who brought a firearm to work, an illegal firearm, and stowed it away in his locker. And the court found that the award should not have been vacated because there was no nexus between his possession of the illegal firearm and the performance of his job duties. And so that fell more into the general considerations of public interest category that could not be a cognizable public policy.
So that's a case where, unlike in this case, the employee violated an explicit policy of the employer about possession of firearms and violated the criminal law by possessing a firearm, the serial number of which had been obliterated, which is a violation of federal law. And nonetheless, despite what one might think of as the criminal law announcing a policy that that's no good, the court said, but if the arbitrator doesn't say fire, the guy can be fired, we are supposed to uphold that.
That's correct, Your Honor. That's how I would also read that case. And so again, I think the Superior Court's reliance on that case was misplaced. And again, if we're looking at that second prong of the test, whether the conduct was integral to the performance of job duties, the Delta Airlines case that is cited there is very instructive and quite obvious. There's a public policy rooted, in statutes, which is against pilots flying planes while intoxicated. It's pretty clear. And in that case, the pilot had been drinking all night and then hopped on a plane to fly some passengers from Boston to Maine or wherever. And in that case, that was a clear violation of public policy because the pilot engaged in the misconduct, which was at the root of the public policy and which was integral to his job.
The other facts here, though, change, if at all, the analysis, because as I read the alleged victim, if you will, of the beep and the rant, did not testify inconsistently from the worker. So in those cases that did recognize a public policy exception, my words, not the case words, was the evidence at odds between what occurred? In other words, here you have the alleged victim basically saying it was no big deal, didn't want it to go anywhere, it was a misunderstanding. Does that factor into whether or not it violates a public policy, what the victim's feelings of it?
Well, I would say I can't think of a case to draw an analogy off the top of my head, but I think the significance of that is that the arbitrator was the only one to hear that testimony and weigh all of the evidence and found that the alleged victim and Mr. Matteo were both credible witnesses, and that Ms. Garcia's testimony was hearsay and it was not reliable and could not be the basis of a discharge. Ms. Garcia was the only one who testified that Mr. Castellanos, the alleged victim, felt fear or intimidated by Mr. Matteo showing up at the NECC. And so the import of that is that the arbitrator made that determination quite clearly in his award, and that was the basis by which he determined that there was no just cause for Mr. Matteo's discharge. By contrast, the Superior Court judge necessarily had to find that Mr. Mattio's conduct in going to Mr. Castellanos' place of employment was improper, which just is not something that the arbitrator found. The arbitrator did not find that Mr. Mattio engaged in disruptive conduct that afternoon. So that's another example of the judge making findings which were directly contrary to the arbitrator. I don't think there's any ambiguity in the arbitrator's award on that point. And on that issue, I would point the court to a number of cases which stand for the proposition that where the arbitrator finds no underlying misconduct with respect to the reasons for a discharge or a discipline, that the public policy exception simply isn't implicated. And there's the Williams case from 2017, Robichaud, as well as Lynn v. Thompson. Those are all cases that stand for that proposition. And I think that's what we have here. The last point that I'd like to make before my time runs out is that the arbitrator also quite clearly made a legal conclusion in his award that he didn't need to consider Mr. Mattio's prior disciplinary record or to decide the parties, frankly, heated dispute about whether it was whether his prior discipline was still active. Because he found Mr. Mattio didn't do the thing that the city had accused him of doing. So at that point, progressive discipline or his prior discipline became irrelevant. And I think the Superior Court misunderstood the concept of progressive discipline in labor arbitration, which is that prior discipline only becomes relevant once you determine that an employee did the thing that they were accused of doing. And you start looking at, well, is this the proper step in terms of, should this employee be terminated, or was suspension more appropriate, or some lesser discipline? And the arbitrator decided he didn't need to go there. By contrast, the Superior Court not only determined that that Mr. Mattio's prior disciplinary record remained active, a legal issue that the arbitrator didn't reach, but also that that it was relevant to the decision, the discharge decision. So I think that's my time. Thank you for your consideration.
Thank you very much. Very well argued. I think we understand your argument. We'll hear now from Attorney Hillman.
Good afternoon, Your Honors. Robert Hillman for the City of Lawrence. May it please the court. To start, if it's okay with the court, I'll jump in on the last point that was made, and that was, and I think it's crucial to the city's position is to what extent did Mr. Mattio do the thing that caused his termination, and how does that come before the court through the arbitrator's decision and the Superior Court's conclusions. And that goes to how this narrow exception to arbitration decisions functions in the law. Not to be redundant, but the manner in which this comes up is a narrow exception to the general rule of finality of arbitration awards. It goes through Chapter 150C, Section 11A3, which refers only to an arbitrator exceeding his or her powers. Courts have defined a doctrine that puts within that statutory language the idea that where a arbitration decision violates public policy, a court may set it aside. An important element of that is...
I'm sorry to interrupt. Can I ask you to specify exactly what is it that the employee was fired for?
For going to Northern Essex Community College following receiving a written reprimand which addressed his interaction with a member of the public, which expressly told him, directed him not to take further action. The exact wording is in the arbitration decision in the record. He went to Northern Essex Community College to confront a member of the public which was concerned with his discipline. And the city of Lawrence, strongly feels that that act meets all three of the elements of the exception to under 150 section 11A3, because the members of the public should not expect, when they are first accosted in public, a matter that would not by itself have gotten Mr. Matteo fired, but that they should be at their place of employment and have that public employee come to them. And the arbitration, there's a difference in the arbitration decision between what may be characterized as findings of fact and then subsequent conclusions based on those findings. But the findings of fact created a firm record on which the city, through its investigation, through its appointing authority hearing, could conclude that that's an outrageous thing for a public employee to do. And
I'm
that
sorry, I need to understand better. What's outrageous about it?
That a member of the public should be confronted by a public employee coming to him or her to question matters that have led to discipline for actions they took while on city time.
The reason that's outrageous is?
I mean, I think it's inherently, I think it could be concluded that that sort of activity is inherently intimidating. And it's also insubordinate in as much as it's contrary to the directive.
You agree that we don't review the findings of fact of the arbitrator at all, right?
I believe that you do not review the findings of fact, and I believe that statement is consistent with the findings.
The findings of fact are that there was no intent to threaten, intimidate, or bully Mr. Castellano, and nor did he threaten, intimidate, or bully Mr. Castellano. So once we have those findings of fact, even if there were this public policy exception, which I don't quite, it seems ill-defined to me, but I'm going to ask you about it in a minute. How could we say that this firing on those facts was required by this public policy?
Two reasons. First, the matter of intent and how the arbitrator managed to divine Mr. Matteo's intent really doesn't matter. It's his presence there.
It didn't have that effect. It didn't have that intent, he said. And by the way, judges all the time and arbitrators have to find intent, but he didn't intend that. And based on Mr. Castellano's credible testimony, it didn't have that effect. So now, I'm not saying that people shouldn't intimidate, they shouldn't. I don't know what the public policy, whether the public policy exception is broad enough, but if that's not what happened, according to the arbitrator who we have to defer to, how can we then conclude that even if there's a public policy, it was violated here?
The fact that that following his reprimand, which instructed him to cease this activity, the mere fact that he went is sufficient.
Okay, that's insubordination. That's not the intimidation piece. That's you were told not to do it, but you did it. Right?
I have a question about whether he was told not to do it.
Me too, but all right.
I mean, the original reprimand, are you saying contains language that says you would have no contact with that individual?
Not in so many words, Your Honor. On page 22 of the record appendix, it reproduces the reprimand that refers to any further infractions of this nature.
Right, and the infraction was using obscenities in a public crosswalk.
That's correct.
So it didn't say he couldn't contact the individual.
The city of Lawrence, through its elected representatives, made a policy call in this case that citizens who report city employees for misconduct should be inherently free of having those people, those public employees, show up at their place of employment to address that.
Well, you also, for some reason, signed a collective bargaining agreement.
Yes.
Right?
Yes,
Now-
yes, the city did, Your Honor. That is absolutely true. We had that
Right,
happen.
so,
to a
I'm not, look, I see more need for it, frankly, here than in other contexts. Arbitration has some crumminesses attached to it. I mean, it also has some efficiencies attached to it. But we're told to defer in all these different ways. And the way I read that highway department case, it says that unless firing is mandatory for this offense, we can't find a violation of public policy in the arbitrator's award that includes reinstatement. And I'm just having a very hard time seeing, one can imagine disciplining this guy without firing him for all of this. He thinks he knows Castellano, maybe he does, maybe he doesn't. And so that's how it goes. He's told not to, no more infractions, but he goes over to try to clear it up. And it's maybe a really bonehead move. You know what I mean? And maybe he gets suspended or something. But I just don't see, this isn't flying an airplane while drunk. That kind of firing offense.
Can I address that, Your Honor? Because I think this sort of, that moves into the third prong of the tests.
It does.
And there is, in the cases that we cited, this notion in that third prong of futility. And that is where the employment record became relevant. This is an employee, when the Superior Court judge remanded the case and asked the arbitrator, can you please further elucidate Mr. Mattio's disciplinary history? And the arbitrator really, didn't respond in a way that the Superior Court requested or expected. But, his one response is, I'm not really going to go into that, but it's appalling. And on the record, which was put into the record, he had a string of 30 years of misconduct, and that termination becomes.
But there's progressive discipline. There's progressive discipline in the collective bargaining agreement you signed, right?
But
so it's fine and good to say that someone who is a repeat offender, that's the one who has to be fired. But whatever your policy is about repeat offender, I assume it's in the progressive discipline portion of your collective bargaining agreement.
I don't think that the collective bargaining agreement is in the record, and we should consult it. But I
haven't looked at that. But I mean,
my recollection of it is that it's a pretty sparse, terse, spare agreement in terms of those kinds of details. But where the city was concerned, it was a situation where it's beyond a last straw. This is an employee who'd been terminated 2 or 3 times previously and resurrected in a variety of ways, and just simply, and we've cited the case law where where courts have said there comes a point with employment, even under a collective bargaining agreement, even public employment, and honestly, it comes down to the citizens of the city of Lawrence, how much do they have to put up with? The Wheeler case is somewhat instructive on this.
It's possible that you shouldn't be signing these collective bargaining agreements, or you should be insisting that something goes into them that says the fourth time a guy is terminated, he's terminated or something. And then, I don't know if you can get that deal or whatever, but that's not what it says.
Yeah, I suspect, leaving aside the rough and tumble world of collective bargaining negotiations, and given the issues that are front and center, yes, I certainly take your point, and that clear language would be helpful. I'm sorry, Justice Blake.
That's okay. I wouldn't disagree with the characterization, maybe, that this particular gentleman was a thorn in the side of the city, and maybe they were looking for a way out. But if you can crystallize for me what, under the third prong, what the public policy was, because I'm still unclear on that issue.
Well, the third prong addresses the inevitability or lack of alternative to termination. The public policy really lives in the first prong, but that is under a series of cases, not the least of which is a case that hasn't been mentioned, but I should. It's the City of Boston versus Boston Police Patrolmen's Association case, the 2004 case. There are actually a lot of cases between the City of Boston and its Police Patrolmen's Union. But that articulates, as does Mass Highway, as does Plymouth Police Brotherhood, that there is a point beyond which an employer does not have to continue to suffer a repeatedly, consistently insubordinate employee. And to the point that came up during the union's argument.
But it's got to be clearly defined. How many insubordinate acts before you are required by law to fire this person?
I mean, admittedly, in the absence of clear language in the collective bargaining agreement, this moves towards toward the range of one knows it when one sees it. But in the terms of
not a clearly defined public policy.
But in terms of this employee in these circumstances with this irredeemable record, somebody who's been fired so many times and just doesn't get it.
We have to write down what the public, if we were going to affirm this, we have to write down what the public policy is so that everyone, every worker, every union, every town will know, oh, this is outside the scope of collective bargaining. You have to fire, and it has to be mandatory. You must fire. Now, I don't mind saying that airlines have to fire drunk pilots. That sounds right. But I'm trying to figure out when a guy who's a basin catcher has to be fired, and I'm having a harder time with that.
Well, if I can suggest language for an opinion, there is language in between the Boston Carmen's Union case and the Mass Highway case that refers to employees' right to terminate employee who, and this is, I believe, taken straight from the case law, repeatedly engages in disruptive conduct detrimental to the employer. That is in sound SJC and appeals court.
Not raising your hand at a meeting 3 times?
I don't know
disruptive.
that. I think it
seems like it's repeated.
I think disruptive in that context has to imply more, obviously, but I'm out of time.
All right, we have your argument. Of course, we have the trial judge's opinion as well. Thank you very much, both of you, for excellent arguments today. It's actually quite an interesting case, to me at least. I can't speak for my colleagues. The case is